Good morning, friends of the media, ladies and gentlemen. Welcome to the briefing on Annual Report 2019 by Mr. Safide, the Commissioner on Interception of Communications and Surveillance. The briefing today will be divided into two parts. Firstly, the Commissioner will introduce the annual report. Then there will be a Q&A section for the media. Please only raise one question at a time. If you would like to ask more than one question, please wait until the Commissioner has finished answering your previous one. For the media representative, please speak your name and the agency you represent before asking. The briefing will be conducted in English. For simultaneous interpretation, please use the mobile receivers. Please select channel 1 for Cantonese, 2 for English, 3 for Putonghua. 0 is the 4th channel for live broadcast. Please kindly switch your phones or other electronic devices to silent or vibration mode. Thank you. 早晨，各位傳媒界嘅朋友、各位先生、女士，歡迎大家出席截取通訊及監察事務專員石輝先生2019年周年報告嘅簡介會。今日嘅簡介會分為兩個環節，第一個環節係由專員為大家簡述報告嘅內容。第二個環節就係傳媒代表嘅發問時間。請大家每次只提出一條問題，等專員回答咗之後先至問下一條。至於傳媒代表就請喺發問之前先講出所代表嘅機構名稱同埋理者嘅姓名。簡介會會以英語進行，如果你需要即時傳譯，請使用大家手上嘅接收器，頻道1係廣東話，2英文，3普通話，0係現場頻道。請大家將手提電話或者其他電子裝置調校至靜音或者震動模式。多謝合作。
Welcome to this briefing. The Interception of Communications and Surveillance Ordinance came into force in August 2006 and was amended in June 2016. It is to regulate the conduct of interception of communications and covert surveillance by the use of surveillance devices by the 4 law enforcement agencies, namely Customs and Excise Department, Hong Kong Police Force, Immigration Department, and Independent Commission Against Corruption. The main function of the Commissioner on Interception of Communications and Surveillance is to oversee the compliance by these 4 law enforcement agencies and their officers with the requirement of the Ordinance, the Code of Practice issued by the Secretary for Security, and terms and conditions of the prescribed authorizations. On 29th of June 2020, I submitted my 5th annual report Annual Report 2019 to the Chief Executive. The report covers the period from January to December 2019. In January 2019, I delivered 2 briefing sessions, one on telecommunication interception and another on COVID surveillance, in a forum held by the Security Bureau on the interception of communications and surveillance for the relevant officers of the 4 law enforcement agencies. The forum provided a valuable opportunity in refreshing the knowledge and awareness of the law enforcement agencies in complying with the requirements of the Interception of Communication and Surveillance Ordinance, and in enhancing their understanding, professional knowledge, and sensitivity in conducting the interception and COVID surveillance in a proper and lawful way. In 2019, a total of 1,335 prescribed authorizations, including fresh and renewal authorizations, were issued, of which 1,310 were judges' authorizations for interception, 22 were judges' authorizations for Type 1 surveillance, and 3 were executive authorizations for Type 2 surveillance issued by designated authorizing officers of the law enforcement agencies. These authorizations included 12 cases that had been renewed more than 5 times. In 2019, 4 applications for interception were refused because the material provided to support the allegations put forth were insufficient. No application for Type 1 or Type 2 surveillance was refused. In 2019, a total of 316 persons were arrested as a result of or further to the interception or COVID surveillance carried out pursuant to prescribed authorizations. The ordinance makes specific reference to legal professional privilege and journalistic material for particular caution when interception or COVID surveillance is to be authorized and carried out. When making an application for a prescribed authorization, the law enforcement agency applicant is obliged to state his assessment of the likelihood of obtaining legal professional privilege information. If subsequently there is anything that transpires which may affect that assessment, the officer concerned has to promptly notify the panel judge of the altered legal professional privilege assessment by way of an REP 11 report, or in the case of a Type 2 surveillance operation, to notify the authorizing officer by way of an REP 13 report. If the subject of the interception or COVID surveillance has been arrested and the officer concerned considers that the operation should continue, the officer should submit a Section 58 report to the relevant authority, assessing the effect of the arrest on the likelihood that any legal professional privilege information will be obtained by continuing the interception or COVID surveillance. The concerned law enforcement agency is required to give the Commissioner a similar notification of each of such occurrences in accordance with the Code of Practice. For cases with assessment that there was likelihood of involving legal professional privilege information, the panel judges would impose additional conditions when they granted the authorization or allowed it to continue. For cases involving information protected by legal professional privilege or journalistic material, officers of the law enforcement agencies below a specific rank should not be assigned for the monitoring duties of the interception concerned. In 2019, I required the law enforcement agencies that if they propose not to restrict monitoring of the interception concerned to officers at a specific rank or above, when making an application for a prescribed authorization or making a report to the panel judge regarding the altered assessment on the likelihood of obtaining legal professional privilege information or journalistic material, they should state in the related application or REP 11 report detailed justifications for the panel judge's consideration. Besides, to ensure an assessment on the likelihood of obtaining legal professional privilege information is properly documented, I recommended to the law enforcement agencies that in cases where an officer suspects that there may be an indication of heightened likelihood of obtaining legal professional privilege in an intercepted communication, but it is later assessed after deliberation by the officer's supervisor that no such likelihood is involved, a note should be made in the relevant transcript to record the assessment made. In 2019, the law enforcement agencies submitted notifications in accordance with the Code of Practice on 117 new cases that were likely to involve legal professional privilege information. 18 of these cases were assessed at the time of application that the operations sought to be authorized would likely obtain information subject to legal professional privilege, and there was no subsequent change in circumstances, one way or another, relating to legal professional privilege likelihood. For the remaining 152 cases, the law enforcement agencies submitted REP 11 or Section 58 reports to the panel judges on the subsequent change in circumstances relating to legal professional privilege involvement or likelihood. These 152 cases included one case of obtaining information suspected to be subject to legal professional privilege, and 151 cases of heightened likelihood of obtaining legal professional privilege information. As regards journalistic material, the ordinance requires the law enforcement agency applicant to set out in the application the likelihood that any information, which may be the contents of any journalistic material, will be obtained by carrying out the interception or covert surveillance sought to be authorized. Also, the Code of Practice provides that the law enforcement agencies should notify the Commissioner of cases where information, which may be the contents of any journalistic material, has been obtained or will likely be obtained through interception or covert surveillance operations. In 2019, reports on 5 new cases with heightened likelihood of obtaining journalistic material were received. The compliance by the law enforcement agencies with the requirements of the ordinance in respect of the interception and covert surveillance cases was reviewed by various forms of checking, which included the checking of weekly reports, the checking of all the relevant documents and records, including the prescribed authorization, REP 11 reports, Section 58 reports, the determination by the panel judge, the notes, the summaries, the communication data, and the audit trail reports, as well as the examination of protected products. In 2019, I had completed the review of the 29 cases of heightened likelihood of obtaining legal professional privilege information that were reported in 2018, but with the authorized operations concern ongoing beyond 2018 and discontinued in 2019. Of the 117 new legal professional privilege cases that were reported in 2019, the authorized operations for 155 cases were discontinued in 2019, and I have completed the review of these 155 cases as well. I have also completed the review of the 5 journalistic material cases. Details of my reviews of these legal professional privilege cases and journalistic material cases are given in Chapter 4 and Chapter 6 of the report. Besides, I have selected from the weekly reports, on the basis of the information provided therein or at random, interception and surveillance products of another cases for examination. During the report period, interception products of 422 authorizations and surveillance products of 6 authorizations that were selected on the basis of selection that I've just mentioned had been examined. Of the 427 authorizations for interception, no irregularity was found for 426 authorizations. As for the remaining authorization, it involved discrepancies made in submitting an REP 11 report to the panel judge. Review of this case is stated in Chapter 6 of the report. With regard to the 6 authorizations for surveillance, notwithstanding that one of these 6 authorizations involved an incident where there was an inaccuracy in the recorded time of a surveillance product, nothing untoward was found during the examination of protected products. In 2019, the preserved protected products of 6 legal professional privilege cases that were reported before 2016 were also checked. Nothing untoward was found for all these 6 cases, and the examination of protected products did not reveal anything to justify any deviation from the assessments given by me or my predecessors on the handling of cases reported in the past years. In 2019, a total of 17 applications for examination made under Section 43 of the Ordinance were received. Of these applications, 1 application was received by me more than 1 year after the day on which the interception or covert surveillance was alleged to have taken place, which came within the ambit of the exception covered by Section 45(1) of the Ordinance and could not be entertained. And 6 applications were subsequently not pursued by the applicants. Of the remaining 10 applications, 4 alleged interception and 6 claimed a combination of interception and covert surveillance. After making all necessary inquiries, I found all these 10 cases not in the applicant's favor and accordingly notified each of them in writing. Under the Ordinance, the Commissioner is not allowed to provide reasons for determination. I have observed that there were occasions that the applicants expressed strong discontent at not being given the details of the reasons for my determinations. It is hoped that the public will understand that the statutory prohibition is designed to forbid the disclosure of any information which might prejudice the prevention or detection of crime or the protection of public security. There should not be any doubt that I carry out my duties and functions under the Ordinance with the utmost good faith and sincerity. Section 48 of the Ordinance obliges the Commissioner to give notice to the relevant person when he discovers a case in which interception or covert surveillance has been carried out by an officer of any of the 4 law enforcement agencies covered by the Ordinance without a prescribed authorization. However, Section 48, subsection 3 provides that the Commissioner shall only give a notice when he considers that doing so would not be prejudicial to the prevention or detection of crime or the protection of public security. Section 48, subsection 6 also exempts the Commissioner from his obligation if the relevant person cannot, after the use of reasonable efforts, be identified or traced, or where he considers that the intrusiveness of the interception or covert surveillance on the relevant person is negligible. In 2019, no notice pursuant to Section 48 of the Ordinance was issued. In 2019, there were 16 cases of non-compliance, irregularity, or incident, while none of them involved reports submitted under Section 54 of the Ordinance. Review of 15 cases was completed. A brief account of the 15 complete cases can be given as follows. 1 case on non-compliance with an additional condition imposed on a prescribed authorization for interception, which restricted officers of the law enforcement agency from assessing interception products involving a specified telephone number. 1 case on incorrect user identity stated in the audit trail reports in respect of monitoring of interception. 1 case on delay in reporting an alias of the subject, which constituted a non-compliance with Section 58A of the Ordinance and paragraphs 116 of the Code of Practice. 1 case on delay in reporting to the panel judge on the previous arrest of a subject of interception. 1 case on inadvertent discontinuance of interception of telecommunications facilities. 1 case on access to interception products during the suspension of monitoring of the interception concerned. 1 case on inaccurate information provided in an REP 11 report. 1 case on inaccuracy in the recorded time of a covert surveillance product. 1 case on failure of the officer concerned in reporting a call to her supervisor for assessment of the likelihood of obtaining legal professional privilege information. 2 cases on failure of the officers concerned in picking up calls with information indicating heightened likelihood of obtaining legal professional privilege information. 1 case on an officer's failure in documenting properly the assessment of the likelihood of obtaining legal professional privilege information of a call. And 3 cases on incidents of technical problems of the computer systems. Please see Chapter 6 of the report for case details. With regard to the remaining 1 case, the law enforcement agency did not timely report the imposition of additional conditions on a prescribed authorization to me. Besides, incompatible surveillance device was issued and surveillance might have been conducted not in compliance with the terms of the authorization. The law enforcement agency concerned submitted a full investigation report to me under Section 54 of the Ordinance in 2020, and a review on the case is still ongoing at the time of writing the report. Details about my review will be reported in the next annual report. Moreover, the review of an outstanding case that was brought forward from the annual report 2018 was completed in 2019, details of which are also set out in Chapter 6 of the report. In 2019, the protected products of 5 past cases of non-compliance, irregularity, or incident that did not involve the obtainment of legal professional privilege information or journalistic material, or such likelihood, including 2 reported in 2009, 2 in 2010, and 1 in 2014, were selected for examination. My findings on these cases are set out in Chapter 6 of the report. Section 52 of the Ordinance provides that if the Commissioner considers that any arrangement made by any law enforcement agency should be changed to better carry out the objects of the Ordinance or the provisions of the Code of Practice, the Commissioner may make such recommendations to the heads of the law enforcement agencies as he thinks fit. 4 recommendations were made to the law enforcement agencies in 2019 to better carry out the objects of the Ordinance. These cover the areas on A, provision of justification for not restricting monitoring of interception to officers at a specific rank or above in legal professional privilege and journalistic material cases. B, reporting of cases where additional conditions are imposed on prescribed authorizations which do not involve information subject to legal professional privilege or journalistic material, and preservation of related protected products. C, record of assessment on the heightened likelihood of obtaining information subject to legal professional privilege. And D, reporting of contents of the intercepted communications which reveal arrest of the subject in the relevant Section 58 report. Please see Chapter 7 of the report for details. The following is my assessment of the overall performance of the law enforcement agencies in their compliance with the relevant requirements of the Interception and Communication and Surveillance Ordinance in 2019. In general, the law enforcement agencies were observed to have continued to adopt a cautious approach in preparing their applications for interception and covert surveillance operations. The interception and covert surveillance operations were in general conducted pursuant to prescribed authorizations granted by the relevant authorities and the additional conditions imposed, but there were still a few cases of non-compliance, as mentioned in Chapter 6 of the report. There was no sign of abuse of surveillance device for any unauthorized purposes. Through the examination of protected products, I am able to check the veracity of the gist of communications or information stated in the REP 11 or REP 13 reports, and whether there were any communications or information subject to legal professional privilege or journalistic material that had been accessed by the officers of the law enforcement agencies, but not reported to the relevant authority. Apart from those specifically mentioned in Chapter 6 of the report, nothing untoward was found for the legal professional privilege cases reported and discontinued in 2019. There was one case on actual obtainment of information subject to legal professional privilege, as detailed in Chapter 4 of the report. I have checked and confirmed that the law enforcement agency had complied with the additional conditions imposed on the prescribed authorization concerned, and the surveillance products passed on to the investigators did not contain any legal professional privilege information. As for the journalistic material cases reported in 2019, they were all found in order. In the handling of legal professional privilege and journalistic material cases, the law enforcement agencies continued to adopt a very cautious approach, but there were still several cases reflecting the failure of some officers in exercising enough vigilance and care on certain occasions, as revealed in the cases reported in Chapter 6 of the report. For an officer who persistently failed to perform interception monitoring duties vigilantly in guarding against the risk of obtaining information subject to legal professional privilege, the law enforcement agencies concerned had removed that officer from carrying out such duties. For all the completed cases of non-compliance, irregularity, or incident reported in Chapter 6 of the report, I did not find that there was deliberate disregard of the statutory provision or the code of practice, nor have I found any ulterior motive or ill will on the part of the officer involved. However, I considered that non-compliance cases on Type 1 surveillance involving misinterpretation of term of the prescribed authorization concerned rather alarming. It reflected the lack of understanding and professional knowledge of the officer concerned in discharging ICSO duty. The mistakes were made by an officer of a rather senior level responsible for ICSO duties and were left unnoticed after a series of internal reviewing process of the law enforcement agency. Most of these cases mentioned under Case 6.1 to 6.12 in Chapter 6 of the report were consequences of inadvertence or carelessness of the officers concerned, reflecting that some of the officers were still not vigilant and cautious enough in discharging ICSO duties. I considered it of utmost importance that all law enforcement agencies and their officers should make every effort to ensure that similar mistakes would not be made again. The heads of the law enforcement agencies should endeavor to provide their officers with sufficient advice and training to facilitate them to better perform the ICSO duties. Furthermore, the officers of the law enforcement agencies should stay alert and exercise care in different stages of the operations conducted under the Ordinance. I am pleased to see that in the report period, the law enforcement agencies continued to be positive to my recommendations in every aspect, aiming for better operation of the ICSO regime, and took initiative to implement system enhancements to prevent recurrence of technical mistakes or to avoid human errors. I wish to take this opportunity to express my sincere gratitude to the panel judges, the Security Bureau, the law enforcement agencies, and the communications services providers for their assistance and cooperation. In particular, I am grateful that relevant parties continued to render great assistance to me in performing the oversight and reviewing functions under the ICSO, without which I could not have performed my functions so smoothly and efficiently. I look forward to the concerted effort of each and every one of the officers involved in ICSO duties in observing the spirit and requirement of the Ordinance, and also the continuous support and cooperation of all the parties involved in facilitating my oversight work. I would also wish to acknowledge the professionalism and dedication of the Secretary and the staff of my Secretariat. The above is my introduction to the Annual Report 2019. Questions are welcome, always heeding the principle that prejudice should not be caused to the prevention or detection of crime or the protection of public security. I shall try my best to answer your questions. Thank you. In view of the fact that no members from the Legislative Council have seen fit to attend this press conference, I shall now open the questioning to the press who are present today at this press conference.
你好啊，我係有線電視嘅，想問幾條中文問題。首先呢，就係睇返即係過往幾年啦，喺所有法定行動之中嘅被逮捕人數啦。2019年呢，成年係即係多過之前啊，即係之前就係之前嗰兩年呢，就係235同埋170。咁即係想知道，例如2019有冇話即係嗰個種類係可唔可以透露下？雖然只係機密，但係係因為啲例如係咩種類，可能係過往發生嗰個反修例事件啦。因為2019年即係成年都有呢件事發生啦。咁係咪因為呢啲行動而多咗咁多被捕人數呢？咁另外呢，就係想問翻個個案嘅，即係報告呢，例如特別提到未完結個案第2個個案嗰度啦，即係由6.7開始。咁見到咧嗰個個案咧係要你哋去訪查先發現，但係其實嗰個嚴重性都幾高。咁會唔會反映到有關嘅執法機關係完全冇警覺性，冇即係自己去監察翻自己人員有冇遵守到有關嗰個截取通訊條例呢？咁同埋有冇因為呢個執法機，可唔可以透露下邊個執法機關啦？同埋呢個執法機關會唔會你哋都會抽查佢哋多啲嘅有關嘅個案，睇下有冇相同嘅情況出現啦？係啦，咁同埋睇到另一宗個案啦，都講到電腦系統故障嘅，但係本身啲人員咧就好信賴個系統啦，咁所以就冇覆檢到。咁其實除咗見到咧，除咗即係例如人為嘅一啲錯誤之外咧，即係硬件上面都有啲問題，會唔會都加強翻建議佢哋，或者甚至你哋去即係同佢哋一齊合作，可能係檢查翻個系統啊，睇下有冇一啲相關嘅問題咧？唔該。
First of all, it should be understood that the number of arrests in any given year stated in the annual report of the Commissioner, that depends on a number of factors. Interception and covert surveillance is but only one factor in the entirety of the scenario. Other factors include what other evidence has been obtained by the law enforcement agencies in their investigation into various cases. And because of the difference in number of factors concerned, it is not possible to come to any specific conclusion from the number of arrests that was made in any particular year. Each case depends on its own facts, depending on what evidence has been obtained and how much of evidence has been obtained apart from the interception or the covert surveillance carried out by the law enforcement agencies in each case. As for the computer system, I'm sure all of you would know from your own experience that on occasions, computer system has its own faults or shortcomings. And whilst the interception regime depends heavily on a very complex, complicated computer system, when it breaks down, when there are faults, when there are bugs, then the entire regime can be seriously affected by such faults of the computer system. Every step has been taken by those engaged in this regime to ensure as far as they can that the computer system works normally. But when it does break down, or when there are faults, these faults will have to be rectified and repaired as quickly as possible to enable the system to run smoothly and efficiently.
Hi, thank you. Several English questions from HKIBC. You mentioned just now that there have been several cases with the officers made repeated failure in, for example, reporting to their supervisor. But then I saw that in the report, most of the disciplinary actions were just verbal advice or verbal warnings. Do you think that if you said that some of those officers have made repeated mistakes in the past years already, do you think those disciplinary actions are really enough? And if it's not enough, then what would you suggest? Another thing is how many, is a trend more, is there increasing number of cases involving non-compliance regarding, for example, accessing to LPP materials or journalistic material this year, or is it a downward trend? Thank you. Compared to last year.
First of all, dealing with the question of disciplinary action, whenever there are any faults found on a particular officer in any of the 4 LEAs who are dealing with interception and or covert surveillance, it is that particular LEA who first decides the disciplinary action to be taken against such an officer. When that decision is made, the commissioner has a say as to whether the disciplinary action proposed is sufficient. if you look into my report, it can be seen that for the entire year 2019, I have not found any of such faults to be deliberate or arising out of ill motive. All the faults that had been found were due to carelessness, lapse of memory, or misunderstanding. As a result, the disciplinary action meted out to each of the officers being advised whether it's disciplinary or non-disciplinary were thought to be acceptable. In 2 cases, the initial proposed disciplinary action were considered not to be sufficient, as those officers had committed carelessness of a higher degree or were repeat offenders. My views were then made known to the particular LEA concerned, and as a result, further action had been taken against the 2 officers in removing those 2 officers from further conducting ICSO duties. They had been removed from ICSO duties and replaced by other officers who would hopefully be more vigilant and cautious. Sorry, I've forgotten your second question.
Is it an upward or downward trend in terms of having
When you compare the report this year, you will see that in the case of LPP information, there was, in 2019, there was only 1 case of actual obtainment of LPP information. And if you look at the report of the earlier year, 2018, you will see that in 2018, there were 8 cases of actual obtainment of LPP information. Now that would suggest that the officers who are dealing with ICSO interception, they are beginning to be more alert and aware as to the risk of obtaining LPP information. And for that reason, I suspect that the number have dropped from 8 to 1. As for the 170 cases of LPP cases, these are not actual obtainment of LPP, but these are cases where there are indications that LPP information may be obtained. So once such an indication is present, panel judges will either revoke the authorization or, if they allow it to continue, will impose strict additional conditions in an attempt to ensure that, or to minimize the chances of actually obtaining LPP information. And that appears to have worked smoothly and efficiently. Insofar as journalistic material is concerned, you will see that in 2019, there were 5 cases where there were indications that journalistic material may be obtained. But in actual fact, in not even one case was any journalistic material obtained from the interception. Again, that shows the alertness and the caution with which officers dealing with interception has gone about their work. Yes.
專員你好啊，香港01嘅，想跟進翻2條問題啦。第一就係即係事故個案入面咧，見到有執法機關咧喺連番檢討入面都唔知係出錯啦，要靠專員去提出啦。咁同埋提到好多係唔小心所致啦。咁其實有冇睇到依家啲機關喺訓練上有冇啲咩不足啦？同埋有冇啲具體嘅建議俾翻佢哋咧？另外就係專員之前都提到啦，其實依家好多人可能比起講電話咧，用一啲 WhatsApp 一啲通訊軟件多㗎。但係目前咧上年專員都提過條例係唔涵蓋呢樣嘢啦。咁專員會唔會即係依家有啲新嘅睇法，或者會唔會有啲新嘅建議，一啲新嘅修例嘅方面嘅睇法咁樣咧？唔該。
Ever since the amendment to the Ordinance was made in 2016, the Commissioner has been given the extra power to check protected products insofar as COVID surveillance is concerned. Now, the ability to check the protected products has resulted in several cases where the Commissioner was able to check and find out certain non-compliances. Again, where these checking showed up non-compliances, these non-compliances were either unaware by the LEAs, and it fell to the Commissioner to check it out for himself from the protected products. However, I should say that insofar as the non-compliance were found, none of them appeared to be deliberate non-compliances. Most of them that were not reported to the Commissioner but were found by checking were non-compliances which arose from negligence or lack of vigilance. Some even to the extent that the negligence was such that it was not known to the LEA themselves, and therefore no report was made to the Commissioner. And it was left to the Commissioner to check it out for himself. But with this extra power of checking the protected products, this has resulted in the Commissioner being able to discover non-compliances which may have escaped the LEA people themselves.
我有兩條問題嘅。第一條問題問咗先呢，就係關於授權截取同埋監察嘅案件入邊呢，係有冇喺2019年呢係涉及反修例事件，而當中呢係有冇人因呢啲行動呢而被捕？呢個係第一個問題。
The Interception of Communication and Surveillance Ordinance, the aim of that is to detect and prevent crime, as well as to protect public security. The protection of public security is defined in the ordinance such that even if there are protests, which is social or political, that will not be deemed to be public security unless it is carried out in a violent manner. This is something that is well known to the panel judges, and no authorization will be issued unless it is for the detection and prevention of crime or for public security. Thus, any applications that are granted by panel judges will have to satisfy the condition laid down in Section 3 of the ordinance, which has to be for the detection or prevention of crime or to protect public security. And it is therefore incumbent upon the law enforcement people to be able to show to the panel judges where they want an authorization to be issued that an offense has been committed or is likely to be committed, or that it is for the protection of public security under the ordinance before such an authorization can be issued.
然後咧係第二個問題，就係喺國安法實施之後咧，其實第43條嘅實施細則咧係定明咗咧，如果喺國家安全嘅罪行又或者係想保護國家安全嘅時候咧，就係一啲監察又或者截取咧係唔需要法官批准嘅，係只係需要特首批准咧就可以進行。咁想問下喺呢個情況之下咧，其實一啲關於國家安全嘅罪行就係專員係咪冇辦法監察，而相關嘅數字係咪唔會公開喺2020嘅年報入邊咧？唔該。
The annual figures disclosed in the 2019 report, or for that matter, the next report, will only deal with ICSO matters. Any offenses or any investigation concerning national security will not be within the ambit or the province of the Commissioner for Interception. All investigation in relation to national security will be completely different, a completely different stream from the ICSO. And the Commissioner has no say in investigation under the national security law, nor will the Commissioner be in any position to review or look into or oversight the investigation relating to national security.
So this is a quick follow-up question from SCMP. So it's now half a year into the enactment of the national security law. Do you think the new practice or the new sweeping police power is unsatisfactory because the chief executive might not have the legal knowledge like you to make the judgments? Thank you.
Well, as I've already said, the investigation of any cases or offenses under national security is completely outside the ambit of the Commissioner for Interception. And that is a question that I'm not in a position to answer. It'll have to be answered either by the Chief Executive or by the Committee for National Security.
Sorry, quick follow-up on that. HIBC. Just now you said that the NSL-related cases would be out of your scope totally, but if the interception is done by the NSL department in the police department, in the police force, then would that still be under your watch, or is it a separate matter for the NSL, the other departments?
National security cases handled by the police. The unit in the police is completely different from those police officers dealing with ICSO matters.
你好，Now TV 嘅，即係專員其實頭先多次提到，因為即係國安法下嘅一啲截取通訊就同你所管轄嘅條例唔同，但即係你做咗專員即係咁長時間，都見到一啲部門可能即係有啲唔小心或者對條例唔熟悉，擔唔擔心即係雖然唔係你嘅管轄，會唔會有人可能即係誤以為適合用嗰個國安法去處理？即係可唔可以分享下你嘅經驗啊？即係怕唔怕呢啲執法部門喺即係做呢啲截取通訊嘅時候，一條新嘅法律底下，即係再由特首去即係負責去批准或者作出申請嘅時候，更加有機會出現呢一啲好似以往你負責嘅條例入邊一啲唔小心一啲疏忽嘅情況出現。第二個問題呢，其實剛才有位記者都問到，就係而家嘅條例呢，未涵蓋到一啲新嘅通訊模式，好似 WhatsApp、Telegram 咁樣。即係你認為去到而家有冇需要個條例真係做一啲嘅修改，先真係可以保障到公眾，或者其實都可能係有助翻執法部門嘅執法？唔該。
Well, human errors, carelessness, negligence is something that all of us live with day in, day out. I mean, to a certain degree and extent, each and every one of us may be careless or negligent in one way or another. And that is something that, as humans, we can never rule that out completely. However, not being the oversight authority for national security laws, how they work and to what extent human beings, police officers, may be careless in carrying out that work, I will not be in a position to say. since I do not have those facts before me. Insofar as amendments to the present ordinance, the ICSO, this is a matter which the government and the Security Bureau constantly keep an eye open for, to see if there are any areas that needs improvement or amendment. As at this moment, my own views is that this ordinance appears to be working smoothly and efficiently insofar as the detection and prevention of crime is concerned. But I'm sure that the Security Bureau and the government will keep its eye open constantly to keep in touch with any new developments which requires amendments to the ordinance.
你好啊，東方日報嘅，想請問一下喺2020年，即係雖然話年報就週年報告未出，咁但係喺2020年有冇已經你記憶所及，有冇已經係有一啲係發出咗定名授權係做截取或者監察嘅調查，係涉及咗國安法嘅 case？ 如果有嘅話，會有幾多宗咁樣？可唔可以透露下？唔該。
As I already said, the ICSO ordinance deals only with detection and prevention of crime. When you say if there are any cases on national security that's been the national security law came into effect in 2020. If any of those offenses created by the national security law is involved, I can only imagine that those cases would be dealt with by the Committee for National Security, Safeguarding National Security, which is completely different from the ICSO. Insofar as the ICSO concerned, any application made to the panel judge will have to be based on an existing offense, an offense which is already in the statute books.
Hello, I'm from TVB Pro. So I have a question about the non-compliances. Even though you said they are not out of ill will, but you still mentioned it was rather alarming. Especially there's a senior level professor involved, officer involved, and it was until like after several rounds of internal review that you found it out instead of them themselves realized the problem. So do you think there's any issue with the government's internal reviewing system or training system? What suggestions would you give for the law enforcement agencies for them to unplug the issue? Thank you.
Oh, that was one case which was quite alarming in itself, as it involved a a senior officer who did not understand the terms of the prescribed authorization. And as a result, a number of mistakes were made. However, the saving grace is that that officer has now been removed from ICSO-related duties, and hopefully such a mistake will not be carried out again, because once that those mistakes came to light, steps had been taken by the concerned LEA to redress the situation. And that can only be done by ensuring that officers dealing with ICSO duties are properly trained and experienced enough to understand and to know the proper workings of the ICSO so as not to commit that same mistake again. The matter, once it came to light, I think steps have now been put into action to redress that situation.
Hi, I'm from RTHK. I know you have mentioned that anything related to national security law is not under your scope, is not under your ambit. So, and is a matter about the Committee on National Security. So, with your view on that, do you think you should be included in that committee to better oversee, surveillance and interception regarding to national security? Concerning you have experience on that. Thank you.
It may well be that, insofar as national security is concerned, if that was also put onto my plate, the Commissioner may well be overworked. Experience can be shared. And the powers that be has seen fit that there is a division of labor such that the national security is put onto the plate of someone else.
Thank you. It's a follow-up question from the above one, because you just said experience can be shared. Does that you mean if like law enforcement agencies or national security related units and the police, if they come to you for advice or ask you for experience of better carrying out such duties, would you be willing to share your experience and give them suggestion? Thank you.
Well, certainly, if they come to me for advice or for sharing of experience, I have no hesitation in withholding what I have learned from these years. But that really is a matter for them, whether they will come to me to ask for advice. Any further questions? If there are no further questions, then I thank you all for your attendance today. And I will call this press conference to a close. Thank you.
Thank you for joining briefing on Annual Report 2019. Before you leave, please remember to return the earphones to our staff at the exit. 多謝大家出席2019年周年報告嘅簡介會。大家喺離開之前，請將耳機還返俾我哋喺出口嘅同事，麻煩晒大家，多謝晒。